afternoon, everyone. And I'd like to add my thanks to CAMS and to MCST for hosting this really great conference with so much interesting information. And I'm pleased to have the opportunity to share our Australian experience of the artist's resale royalty right. So just a quick overview of what I'm going to cover. Talk to you a little bit about copyright agency, and then we'll look at an overview of resale royalty right in Australia, how it was introduced and the process that we went through, and then some of the practical operational aspects of it, and also a little bit of a look at the post-introduction impact and the feedback from artists and the art market. So turning to copyright agency, we all seem to be having birthdays. We were 50 years old last year, established in 1974 by authors and publishers to manage primarily copying in Australian educational institutions. We later expanded to represent other creators, including visual artists. In 2010, when Australia's resale royalty system was introduced, Copyright Agency was appointed by the Australian government to establish and manage the system for collecting the royalty and paying rights holders. And in 2017, Copyright Agency merged with the Australian Visual Arts CMO VisCopy. VisCopy was itself established in the mid-1990s as a dedicated visual arts CMO. So when that merger took place, Copyright Agency took over the visual arts licensing activities. And so now we manage a wide variety of statutory and voluntary licensing schemes, including for government, businesses, media monitors, art museums, art auction houses and commercial galleries. Copyright Agency is a member of IFRO and CSAC and has reciprocal rights management agreements with over 50 foreign CMOs and RROs, including SAC and COLA in Korea. And finally, like some of the other societies, like Bildrecht, for example, we operate a cultural fund which supports significant projects to benefit Australian writers, visual artists, publishers and creative organisations. And we take a percentage, 1.5% of our collections, except for resale royalty collections, to fund that particular fund. So just a quick overview of resale royalty in Australia. The purpose of the law, as with all of the resale royalty schemes, is to recognise artists' ongoing economic rights in the value of their work and to provide income from the resale of their works. So our scheme involves the receipt of a royalty of 5% of the sale price, and I'll talk a little bit more about why we have that royalty. For eligible commercial resales of their work. And our scheme, as I mentioned, was introduced in 2010. The start date was 9 June, and that's a particularly important date for reasons that will become obvious shortly. So when is an artwork eligible for a resale royalty? So it has to be over the threshold of 1,000 Australian dollars, which is around about 400,000 Korean won at current exchange rate. So that is of course around about the equivalent of the UK threshold. The artist has to be a citizen or permanent resident of Australia or a national or citizen of a reciprocating country. And I'll talk a bit more about reciprocity shortly. Now, the reason the 9 June 2010 date is important is because in order to be eligible, the seller of the work has to have acquired it after the start of the scheme. If a seller holds a work prior to the start of the scheme, then the first commercial resale will not be eligible. The artist needs to be alive or deceased no more than 70 years, as with other schemes, such as the UK scheme. If the artist is deceased, then the beneficiary can collect the royalty, but the beneficiary has to meet a particular succession test. In other words, they have to have acquired the right by will or under the laws of intestacy, and they also have to meet a residency test. So the beneficiary has to also be either Australian or a relevant foreign rights holder. Turning to international reciprocity, so when the scheme was introduced in 2010, it was applicable only to Australian rights holders. The government didn't extend it to foreign countries. And there are various reasons for that, but it was a little bit like Rima was describing the lobbying that occurred in the UK, which led to essentially some compromises, such as the fact that beneficiaries weren't initially included. The government was interested in appeasing the art market and sort of taking a slowly approach to see how the scheme worked before they were prepared to extend it to international countries. But that changed on the 31st of March 2004, when the first list of reciprocating countries was prescribed under the legislation. And these countries have all been selected because they have collectively managed ARR schemes operated by CMOs with whom Copyright Agency has a reciprocal agreement. And then there was a second list of countries which was prescribed on the 31st of March this year, and that includes New Zealand, which, as Ben has said, has just introduced their scheme. And we are hopeful, of course, that Korea will be added as a reciprocating country, perhaps in 2027. So looking at the results to date, since June 2010, more than 15 million Australian dollars have been collected. Now, actually, that figure is slightly out of date, and it's actually now over 16 million. I found out the other day when we did some updated calculations. So it's a bit over $1 million a year in royalties that have been collected, which, considering some of the limitations of our scheme, is quite good. Nearly 3,000 artists have benefited over that time from 33,000 resales. And most royalties, interestingly, are between $50 and $500, so they're not necessarily huge payments. Turning to the comparison with visual arts copyright management, so the Resale Royalty Scheme is governed by the Resale Royalty for Visual Artists Act 2009, whereas copyright is governed by the Copyright Act 1968. So the government chose to separate those two pieces of legislation. Copyright Agency is authorised by the Australian Government to collect resale royalties under the resale legislation and copyright royalties under the Copyright Act. The other thing about it is the two schemes are actually administered by two different government departments. Our Attorney General's Department, which is generally responsible for legal matters, administers our Copyright Act, and the resale royalty legislation is administered by our Department of Arts, this is the federal government. That's really, sometimes that changes depending on the government in power at the time, but it seems to work reasonably well. The departments generally cooperate very well together. So visual arts copyright licensing requires a mandate from artists, and with the merger between Copyright Agency and VisCopy in 2017, we added VisCopy's large repertoire of Australian and international artists to its own repertoire. So we have a very broad mandate from a very large number of artists to manage their copyright. However, of course, resale royalty is, we're mandated by the legislation. We don't need a specific mandate from artists to manage the royalty, although it is subject to an opt-out. And the image in this slide, by the way, is one of our Aboriginal artist members whose works we've licensed. just looking at the process that led up to the introduction of resale right in Australia. It was a very long process. Rima mentioned the Berne Convention having introduced resale right in the 1940s. Australia acceded to the Berne Convention in 1977, and of course it includes the voluntary resale right. In 1989, our Australian Copyright Council produced a report recommending that Australia introduce a resale right to implement Article 14 of the Berne Convention. And the image in this slide is an artwork by an Australian Aboriginal artist named Johnny Warrankoola Japarula. And the resale of this work in July 2000 for 486,500 Australian dollars after its original purchase in 1975 for $150 stimulated debate on resale royalty. It was an example of where there can be a huge discrepancy between what a work sold for originally and what it sells for a decade or so later, and the fact that the only people benefiting from that huge increase in value were the seller and the buyer and the art market professional, essentially. And this was particularly pronounced in the community of Aboriginal artists. So it was quite some time, as I say, before the idea of a resale right took hold. In 2001, the government commissioned a report into the visual arts and crafts sector, and that recommended the introduction of ARR. Then it wasn't until 2004 that the government issued a discussion paper and sought submissions on whether ARR should be introduced. There was a lot of consultation. And then it wasn't until 2008 that the government finally decided to proceed, and it introduced into federal parliament a bill for an act to create a scheme. It also set aside $1.5 million worth of funding to support the establishment of the scheme. And then even after that decision was made, there was still extensive consultation which occurred with all affected parties, artists, art market professionals, and other relevant industry players. And then there was a parliamentary, as is often the case with legislation that's new and sometimes controversial, there was a parliamentary committee hearing into it, and the committee looked at it and recommended some changes to the bill. And so the process continued. The government did actually make some changes to the bill but didn't accept all of the committee's recommendations, and then ultimately the bill passed through the Parliament and became the Act that we now have. And the government decided, even though resale royalty right is operated around the world, generally speaking, by the visual arts CMO of that country, our government decided that it would establish a competitive tender process to select the organisation who would run the resale royalty process. And VisCopy and Copyright Agency both tendered, and Copyright Agency was selected and appointed. And I think it's the larger society, the more well-established society was the one selected to run the scheme. So Copyright Agency created a website, an IT system and a communications campaign with the funding that the government provided. It also set up an artist advisory panel and an art market advisory panel to assist with establishing the scheme and communicating with artists and the art market. It was very important to engage in the markets to prepare people for the introduction of the scheme. We also launched various advertising campaigns, and this is an example from 2012, to raise awareness and to let people know. Let artists know that they have a new right, and to let the art market know that they now have obligations. So just looking at the design considerations of the scheme, I was asked to look at why our scheme differs from other schemes, particularly the European scheme and the UK scheme. While it shares many things in common, there are some differences. And the Parliamentary Committee, which looked at the scheme, did recommend that the design and structure should be broadly similar to existing foreign schemes in order to maximise reciprocity benefits. The government was concerned about three particular things. One is a constitutional provision, that is a provision in our federal constitution which prohibits the government from acquiring property from private citizens unless it pays fair compensation. It was concerned that introducing a resale right that might apply to people who already owned artwork could fall foul of that provision. It was also concerned about the expressed desire of artists to control the right themselves. So some artists approached the government to say, we'd love a resale royalty right, but we want to be able to collect it ourselves if we choose to. We don't want to have to collect it through a collecting society. And the third thing that the government was bearing in mind was the particular need to benefit Aboriginal and Torres Strait Islander or Indigenous Australian artists. So the key features that are of note are the second resale, which I've already mentioned. The fact that if you owned a work at the date of the introduction, then the first resale, commercial resale of that work would not attract a royalty, and this was the government's solution for the constitutional problem. I have to say, we in the collecting society world and the art and artists did argue against this and said it wasn't necessary, but the government was not convinced. Then the second issue, addressing this idea that artists want to collect the royalty themselves, the government decided to design a scheme that allowed artists to opt out. So the collecting society would still have the obligation to collect information about the resale and actually publish information about the resale on its website. But then the artist, having seen that notification, can then choose to say, well, thank you for that, but I will collect, or I don't want you, the collecting society, to collect it, I will collect it themselves. So this was the government giving the artists some agency. And then a couple of other features, the flat royalty rate of 5% as opposed to a tiered rate that we have in that the UK and Europe has. I think the rationale for that was that there was a recognition that the second resale rule was going to mean that the scheme was not going to grow as quickly as it otherwise would. It would be of a smaller value, and therefore having a 5% flat rate would simplify the administration and also offset some of the downsides of having a second resale. And similarly, a decision not to have a cap on royalties as well. I think the same rationale there, that one, simplicity of administration, and two, helping the scheme along, essentially. And then the administration fee charged by the collecting society is actually set by regulation. Initially, the government had it at 10%, but after a few years of operation, it was recognised that it was costing the collecting society more than 10% of the total collections to run the scheme, so the government increased that administration fee to 15%. So just in terms of the way the scheme operates in practice, so what happens is that Copyright Agency gathers information about resale royalties. Now, the art market is supposed to report, sellers are supposed to report to us, art market professionals on behalf of sellers are supposed to report to us, and then we publish a notification of those resales on our website. Then, as I say, there's this opt-out period. It's actually 21 days the artist has. If they have not opted out within 21 days of the notice then we have the right to collect. And we have a website via which artists, beneficiaries and art market professionals register. They can upload their resale reports via the website, and we determine the eligibility of the resales that are reported to us according to the various criteria. And then we will, if we deem it eligible, we will then invoice the art market professional, generally speaking. And as a condition of our appointment by the government, we actually provide monthly and 6-monthly reports and operational plans and annual reports to the Office of the Arts. So we have a very close relationship with the government department administering the scheme. And we also meet with them regularly to discuss how it operates in practice. And we've just last month, launched a new resale royalty website. We needed to rebuild or build a new IT system because, of course, these things have a shelf life. It was coming to the end of its life, and we needed to refresh it for international reciprocity. So we've built both a new external website and an internal system. So this is just a screenshot from the front page. And then this is an example of the inside the portal where an art market professional can upload an Excel spreadsheet of the resales they're reporting or use an online reporting form, depending on which they prefer. And this is an example page of where we report notices of resales. So we will add them here, the artist's name, the artwork title, the medium, and then the opt-out deadline, which of course, as I said, is 21 days from the date we publish the notice. Then in terms of the compliance activity, so the main means of compliance is through a section in our legislation which requires sellers, buyers and art market professionals to provide information about resales within 90 days of a notice. So we can send out a notice and say, we're aware that these resales have occurred, and we monitor their art market professionals' websites, for example, and other means of activity. There are also art auction databases that we can get access to. And we say, if they haven't reported proactively to us, we will say to them, you need to report these resales to us and provide us with all the relevant information so we can determine eligibility, and you have 90 days to do that. And then if they don't, then there are penalties that can apply to that. In fact, they're quite steep penalties. They're set in legislation. We have not actually yet brought a penalty case. We haven't had to. Generally speaking, we've had good compliance, proactive compliance, but we've also generally had compliance as a result of these Section 29 notices. However, there may come a day when we do actually have to take legal action, and we'll have to test the legislation and see how it actually operates in practice. And then finally, looking at some of the post-introduction impact. So the government, when it introduced the scheme, promised that it would review its operation after 3 years or so. So it was in 2013 it commissioned a post-implementation review. The review found that stakeholder views were polarised, unsurprisingly. The scheme was generally viewed positively by artists and art organisations, but negatively by AMPs and art investors. On the positive side, however, overall the review found that the scheme and its legislation remained appropriate and that it was achieving its key objective of providing financial returns to artists. So Copyright Agency's experience is that artists and beneficiaries are overwhelmingly in favour of the art market, of our ARR, and art market professionals are generally cooperative, if begrudgingly sometimes. The other thing that's also clear is that the concerns that were expressed by the art market and others before the introduction of the scheme, including about the privacy of buyers and sellers, that the scheme would not be efficient or effective, that it would be difficult to pay artists and beneficiaries, and that few artists would see any benefits, have not been justified. Those fears have not been borne out. And just in terms of a couple of figures, so around about 65% of the recipients individual recipients of the resale royalty right are Indigenous artists, but they receive around about 42% of the value. So in other words, the majority of the value is actually going to non-Indigenous artists, which does make sense given the relative population breakdowns, but they are benefiting at a high level. The other thing that's good is that 86% of recipients are living artists, not deceased artists, although again, living artists receive a smaller share of the actual value, and around about 60% of the value goes to deceased artists. But again, that makes sense because as art often appreciates, as we know, after the death of an artist, and for that whole 70-year period, and the art just continues to get more and more valuable. And like Rima, I'll just finish with a couple of comments. The image in this work is a beautiful mosaic which is in front of Australia's Federal Parliament, created by an artist called Dr. Michael Nelson Jagamara. He said, "I agree with that idea, resale royalty. It is good for artists and family. It is important for Aboriginal artists, especially if they pass away, that royalty goes to their families. It is good that they can get a share of that resale royalty." And an art market operator said, who works with Indigenous artists, said the resale royalty scheme has had a significant positive impact on Indigenous artists in and around Alice Springs, which of course is in Central Australia, and they have developed new understandings and experiences of the art market because of it. And one of Australia's now deceased but most important non-Indigenous artist, Charles Blackman, he, towards the end of his life, was unable to paint anymore, but he relied heavily on income, both from copyright licensing and from resale royalty, to support him in his old age. So thank you very much for your attention.